Alex here with a criminal video on Coram Nobis. This is another one of those obscure writs that I'm getting questions on. I did a video recently on quo warranto, and so I figured I would do this one really quickly as well. I'm not looking into every teeny tiny detail, every nook and cranny as to how these really obscure, rarely used writs work, but since I get enough questions on them, I do eventually get to the point where I at least want to do a video and let people know what I do know about it, which again, I stress is very limited. Coram Nobis is apparently a writ that is used that can force an appellate court to consider facts outside the record, facts that were not available to the lower court that are available now that would have affected the outcome of a criminal proceeding. There are for some reason, this only applies to criminal proceedings. I'm not sure as to why, but at least as far as it works in Nevada, you can only use it in Nevada with regards to criminal convictions. And it is basically used to vacate a conviction. So there are a tremendous number of cases on this in Nevada, and a whole bunch of different angles are contemplated. The first being the fact that it comes from, or at least the authority to use it comes from the Constitution, the Nevada Constitution. And the legislature has fashioned a multitude of statutes that alter and narrow its use. My understanding is that there may even be statutes that forbid or abolish the writ of Coram Nobis, but because the Constitution is more powerful than those statutes, the Supreme Court of Nevada, and again, I may be wrong, but from what I have looked at, the Supreme Court of Nevada will allow, or does allow, the writ of Coram Nobis to continue to be used in rare circumstances. And those circumstances appear to be circumstances where no other remedy is available. And they stress this, at least in the case that I looked at. For example, if you are still in jail, if you are still imprisoned, the Supreme Court of Nevada has indicated that there are other remedies available to correct errors. For example, habeas corpus, it's another writ. And the legislature has fashioned a whole bunch of statutes about around the writ of habeas corpus and how it is supposed to be used. And if you can get relief under the writ of habeas corpus, they will deny any relief you are seeking under Coram Nobis. So I mentioned earlier, if you're still, incarcerated, you're going to be able to use habeas corpus to solve whatever problem you are bringing up, whether it's ineffective assistance of counsel, meaning your counsel was so incompetent that you may as well not have even had any. In the context of what you're entitled to under the Sixth Amendment, I stress that because some people try to use it in other types of cases, and the Sixth Amendment gives you counsel only in criminal cases under certain circumstances, not even all criminal cases. You can't use it in like a civil case. But anyway, getting slightly off track, getting back on track now. You can't use it if you're still in prison because you could instead use habeas corpus. And there are also other statutory remedies available that a defendant or an inmate could use depending on where they're at in their proceedings. And so if those are available, the inmate or defendant has to use those instead. They can't use Coram Nobis. So from what it seems, at least right now, in practice, Coram Nobis is used by people who are already out of jail or who have already been released, and they can't use habeas corpus because habeas corpus has to do with ordering whoever it is that has you imprisoned, ordering them to appear in court to produce you before the court and explain by what authority do they have you imprisoned. And it could be a warden, but it's also something that can be used in other contexts as well. Like, I don't know, maybe if somebody's being detained at a mental health facility or something like that, something similar. If you're not being detained, you can't use habeas corpus. There is nobody to force to address the court and explain by what authority you're being detained because you're free now. You're not being detained anymore. So that is one example where somebody can use Coram Nobis to attack the judgment of conviction after the fact. Now that they're free, they need some kind of mechanism to clear their name, and now let's assume that they've served their time for, I don't know, like a sexual assault, and now they're free, but new evidence has arisen. I don't know, DNA evidence, or maybe something along those lines has come up that makes it so that you, I don't know, maybe you can show that it's impossible for you to have actually committed that crime. They have something called actual innocence, and actual innocence is a powerful way to fight a conviction. That's just an example. Let's say that's something you're trying to do. You're not in jail anymore. You're not in prison anymore. You've served your time, but you still want to clear your name. It appears to me that you can use the writ of Coram Nobis to do so. With the new evidence that is available now, that wasn't available before, that's not in the record, that you want to bring to the attention of a court, whether it's the Supreme Court or the District Court, I don't know. I think this is the best that I can really do when it comes to Coram Nobis. I'm going to try to wrap it up now at the end. It's used to correct errors. It's used to overturn or vacate a conviction based on facts that were not in the record at the time of the conviction, that are available now, and that you would be entitled to relief on. And of course, the last and almost most important, but not really, it's the most technically important piece of it, is that there's no other remedy available to you. So I'm going to go ahead and end this video now. If anyone has any questions on Coram Nobis, feel free to post in the comments below, but please be advised that I know only a skin-deep amount of information on it, and I did the best that I could with this video. So I'll see you guys next time.